A Hail Mary attempt by the ex-president's lawyers to just call it a wrap, and the New York civil fraud trial has failed. The day after the New York Attorney General's office rested its case, Trump's lawyers asked Judge Arthur Engoron to clear Trump's companies and top executives from Trump's companies from any and all wrongdoing, seeking what is known as a directed verdict. Judge Engoron did no such thing. He did not issue a ruling, but it is worth noting that he has already said that he's found proof of years of fraud. And he said that the trial will go on for now. On Monday, Donald Trump Jr. will return to the stand as the first witness for the defense, with the trial revealing a steady drip of damning allegations about the Trump business and leading to a gag order for Trump. The GOP has stepped in now to carry some of the ex-president's water as he flails. As Andrew mentioned in the earlier block, House GOP Conference Chair Elise Stefanik filed an ethics complaint today against Judge Engoron. In that complaint, she accuses the judge of weaponized lawfare against the ex-president and called on the judge to recuse himself. Joining me at the table, MSNBC legal analyst Lisa Rubin, who has been literally on the front lines covering this trial for us here. Andrew is with us. Let's deal with Elise Stefanik, because Andrew teed this up in our last conversation. Is there any merit to the allegation, or is it to be viewed purely? I mean, she's always sort of been there to carry Trump's water when he's been on trial. In a congressional sense, is this the same?
Yes and no. So let's start by saying Elise Stefanik's letter begins with a bunch of partial and selective quotations from hearings that, read in their entirety, are not, I don't think, evocative of bias. For example, the quote about her saying that Judge Engoron characterized Donald Trump as just a bad guy, that was him responding to allegations that Trump was being selectively prosecuted, saying repeatedly he doesn't fit into a protective class and that the Attorney General is within her rights to make the decision that he is just a bad guy who needs to be prosecuted for his crimes. That's just one example of the selective quotation. The campaign contribution allegations, Nicole, are of a different variety, and they may turn out to be true and a violation of New York rules of judicial conduct. However, I've consulted with a fairly prominent lawyer, very well versed in these rules, and that person tells me that's not a basis for invalidating or overturning any of these decisions on appeal. It's not a basis even for removing Judge Arthur Engoron from the case. If anything, it would be the basis for discipline. And I think the Trump lawyers knew that. They were hinting at these allegations about the campaign contributions that had emanated from a Breitbart report late last week. And then they told the judge on Monday, the same day Trump was on the stand, that they intended to make a motion for mistrial about them. My guess is that they realized that it's not the basis for a mistrial. It's not the basis for an appeal. And so what did they do? They got Elise Stefanik to be a part of this complaint and put it in her voice to a different body, not to a court, but to a commission on judicial conduct, where it sits under New York rules until they decide it should be dismissed or investigated. And that could take months, which means the allegations will stay out there unchallenged unless Engoron himself decides to take them on.
I mean, this is the exact conversation we were just having about institutions like the FBI and the military that can't defend themselves from baseless attacks, that they're not structurally or culturally positioned to respond to political attacks. And it sounds like Elise Stefanik just put in the letter the kind of thing she'd say on Fox News.
Well, the letter, I also want to be clear, the letter looks like a legal brief. It is heavily footnoted. It contains citations to case law and statutes. It appears as if it were written by a lawyer, which Elise Stefanik, for all the things that she is, right, a White House alum, a mom, a Harvard graduate, is not. So I have a belief that Elise Stefanik was brought into this effort when they realized that using these allegations as the basis to get rid of this case wasn't going to work.
Andrew Weitzman, what is the path forward here? What do you think happens next?
Well, I think that the trial is going to go forward. This is an opportunity with respect to a number of the causes of action that have not been decided for Donald Trump and Don Jr. and Eric Trump and the entities to say why there isn't the requisite intent, there isn't materiality, why they acted in good faith. They can put on evidences to that. Remember, these causes of action, the ones that are on trial, are different than the one cause of action that Judge Engoron ruled in favor of the state. That already happened before the trial began in a summary judgment motion, but that cause of action didn't require, even though it's called fraud, didn't require the state to prove intent or materiality. So I think a lot of the evidence you hear will go to that, to the extent that the evidence is going to legal issues and not just making political speeches. There certainly will be a fair amount of the latter. But on the law part, it will be focused on, again, intent and materiality. And then, just to be clear, the next part is that the state will get a chance to respond to those allegations. So this will take several more weeks. The defense has said that they expect their case to last until December 15th. So
Wow.
we have quite a ways to go.
What do you make of Don Jr. as the first defense witness? What is the strategy behind that?
I don't quite know, other than that.
Okay, it's not just me.
No, it's not just you. Other than Don Jr. and Eric, as the two principal leaders of the business right now, have a stake in defending themselves against one of the aspects of relief that the Attorney General has asked for, which is a lifetime ban on their conducting business in the state of New York. And so, based on something one of their lawyers said last week, I think that would be a metric that would hurt both Trump brothers very seriously in the conduct of the business, even if the businesses themselves were not dissolved. Don Jr. has a desire to come and defend himself and do so in a way that goes beyond the scope of the Attorney General's direct examination last week. Andrew can tell you that one of the reasons they didn't want to cross-examine their own witnesses is not just because they're not hostile to them, it's because they want to elicit testimony on subjects that go well beyond what the Attorney General is interested in. And so I would expect them to go into, at great length, the relationship that both boys had with the accountants, with the lawyers, how they spent their days, which they have insisted was at a very high macro level of management, but yet...
Except one of them poured concrete.
Yeah, he poured concrete.
I don't remember which one.
It was Eric,
yeah,
who poured concrete. He was into operations, he said, not into GAAP. And they're going to have to sort of thread that needle very carefully, that they were expert in the real estate angle of the business, and yet not so steeped in any of the details relating to their family finances that they can be held accountable for the intent that Andrew says, rightly, is an element of the remaining claims here.